All right, everybody. It is about 7:40 p.m. West Coast time on Wednesday, August 20th. Today, we got an order from a federal judge in the United States District Court, Southern District of New York, named Richard Berman, denying again the Trump administration's request that the grand jury materials from United States versus Epstein, Jeffrey Epstein, be released publicly. Typically, all grand jury materials, testimony, exhibits are kept secret and confidential and are only made available to the public under very specific circumstances. The judge found that those circumstances do not exist in this case. So what I'm going to do is read the order to you guys. It's short. It's only like 13 pages long, 14 pages long. And the way these orders are structured, and the flow will make sense to you once I get into it. There's a factual introduction about what is happening right now. Then there is a background section, and that contains a factual history that leads up to this motion. Then there is a section that's called the legal standard, and this lays out the law or laws that the judge must apply in this case. And then there is a section called the discussion section, where the judge applies those laws to these facts and goes through them until the very end, where the judge reaches his conclusion. And so I'm going to walk you through this so that you guys can understand how these things work and what these judges actually do when they're considering a motion like this from the government, and how they consider the things that they consider when they're making a decision. All right, so let's dive in. Having reviewed, among other things, the government's motion dated July 18th, 2025, to unseal the grand jury transcripts in United States versus Epstein, and the government's motion dated August 8th, 2025, to unseal the exhibits related to the transcripts, as well as the grand jury transcripts dated June and July 2019, which together total 70 pages. So we're only talking about 70 pages of testimony here. Testimony transcripts. The court reviewed the grand jury exhibits, a PowerPoint presentation, and 4 pages of call logs. The court reviewed 2 letters dated August 5th from attorneys for Epstein victims, as well as 2 letters from individual victims themselves. The court reviewed a letter from the Epstein estate executors, and the court reviewed the opinion and order dated August 11th, 2025 in United States versus Ghislaine Maxwell, denying the government's motion to unseal the Maxwell grand jury transcripts and exhibits. Having reviewed all of those things, in this case, the court denies the government's motions to unseal the Epstein grand jury transcripts and exhibits. The principal ruling in this case is that Federal Rule of Criminal Procedure 6E governs, and that there is clear precedent and sound purpose for grand jury sealing the transcripts and evidence. The government concedes that no Rule 6E3 exceptions to grand jury secrecy apply to this case. The government is saying none of those exceptions in the statute apply to this case. At the same time, the government fails to demonstrate any special circumstances which might justify the unsealing. Now we get into the background. Jeffrey Epstein was first investigated for sex crimes against minor girls in 2005 by the Palm Beach, Florida Police Department. The investigation also involved the U.S. Attorney's Office for the Southern District of Florida. In the fall of 2007, Epstein entered into a non-prosecution agreement with the Southern District of Florida based upon Epstein's abuse of minor girls. And in June 2008, Epstein pled guilty in the state of Florida to 1 count of procuring a person under the age of 18 for prostitution, a felony, and 1 count of solicitation for prostitution, also a felony. Epstein was sentenced to 18 months in prison, although he served only 13 months in a work release program. Epstein was also required to register as a sex offender. On July 2nd, 2019, Epstein was indicted in the Southern District of New York on one count of sex trafficking conspiracy and on one count of sex trafficking. That indictment was dated July 2nd, 2019. Epstein was arrested on July 8th, 2019. On July 18th, 2019, this court remanded Epstein to custody, meaning he had to stay in jail pending his trial, finding that he posed a threat to additional young girls if he were released. The court also found that Epstein or his representatives had intimidated, threatened, and/or made payments to potential witnesses, and that Epstein was not always compliant with his legal obligations as a registered sex offender. While awaiting trial, Epstein was found dead in his cell at the Metropolitan Correctional Center on August 10, 2019. Soon thereafter, the government requested that the court enter an order withdrawing the prosecution. Prosecutor at that hearing: the government is legally obligated to seek a dismissal of the pending indictment against Jeffrey Epstein, and we respectfully submit that the entry of the proposed order is similarly required by law. At the August 27, 2019 hearing, the court also heard from no less than 23 of Epstein's victims. Attorney David Boies, who represented several of the victims, said the following: "How proud I am of all of these women who have come forward. It's taken an enormous amount of strength and courage for them to do so." Annie Farmer, one of Epstein's earliest victims, said the following: "I think this is really a important signal to send a message to victims out there that people will take you seriously, people will follow through, and that even those in power will be held accountable." Now we get to the legal standard. The rule of grand jury secrecy, Federal Rule of Criminal Procedure 6E, reflects the important ways in which it is said to contribute to the success of grand juries and to the protection of those who appear before them. Rule 6E requires that grand jury activities be secret for the following reasons, and there are 5 factors: to prevent the escape of those whose indictment may be contemplated, meaning the alleged perp doesn't catch wind of it ahead of time and leave; to ensure the utmost freedom of the grand jury in its deliberations, and to prevent persons subject to indictment or their friends from importuning the grand jurors. 3, like illegally contacting them, things like that. To prevent subornation of perjury or tampering with witnesses who may testify before grand jury and later appear at trial of those indicted by it. 4, to encourage free and untrammeled disclosures by persons who have information with respect to the commission of crimes. And 5, to protect innocent accused who is exonerated from the disclosure of the fact that he has been under investigation and from the expensive standing trial where there was probably no guilt. Meaning that if a grand jury goes through its process and a prosecutor is asking them to indict someone, if the grand jury fails to indict, then that person is spared the publicity of this grand jury has been meeting about this person for the last 6 months, even though they failed to indict. Continuing on, there are several limited exceptions to grand jury secrecy under Rule 6E3, which resolve almost all applications for unsealing of grand jury records. The Second and Seventh Circuit Court of Appeals also review special circumstances in which the release of grand jury records is appropriate, even outside the boundaries of that rule. District courts in the Second Circuit determine whether exceptions to grand jury secrecy apply and when disclosure of records may be appropriate. Disclosure of grand jury materials outside of the exceptions under Rule 6E involve special conditions which rest on the exercise of the sound discretion of the trial court. In analyzing the special condition exceptions, district courts follow the 9 so-called In re Craig factors. In re Craig is a case name, so this means that there was a case involving someone whose last name was Craig, and that court came up with 9 factors. And then we're going to go through those 9 factors until we get to a conclusion. Those 9 factors are the identity of the party seeking disclosure, whether the defendant to the grand jury proceeding or government opposes the disclosure, why disclosure is being sought in this particular case, what specific information is being sought for disclosure, how long ago the grand jury proceedings took place, the current status of the principals of the grand jury proceedings and that of their families, the extent to which the desired material, either permissibly or impermissibly, has been made public, whether witnesses to the grand jury proceedings who might be affected by disclosure are still alive, and the additional need for maintaining secrecy in the particular case in question. The parties seeking to unseal grand jury materials must demonstrate that unsealing is appropriate. The burden is on the requester to demonstrate that disclosure is appropriate, and the baseline presumption is against disclosure, meaning the starting point for the court is, I'm not disclosing this stuff. That's the presumption. And then the party requesting unsealing has to go through those 9 factors that I just read in order to demonstrate to the court that unsealing is appropriate. Discussion section. The government concedes that it cannot meet any of the exceptions specified in Rule 6E. Rather, the government contends that unsealing is warranted under particular special conditions, namely a public interest exception. Contrary to the government's depiction, the grand jury testimony is not a matter of significant historical or public interest. Far from it. There is certainly and appropriately lots of discussion about the Epstein case, and for that reason, the court is proceeding to evaluate the validity of the government's special condition claim under the 9 Craig factors that I just read. Factor 1, identity of the party seeking disclosure. The government is the party seeking disclosure, however unusual it is for the government to seek to unseal grand jury material. Not since the 1973 Biaggi case has the government sought to unseal grand jury materials based upon special circumstances. So 52 years. The government's argument for unsealing is not dispositive and should not be taken as demanding or even authorizing public disclosure of a witness's grand jury testimony. In a couple minutes, I'm going to get to what the actual witness grand jury testimony in this case is. It was a single FBI agent who offered hearsay testimony. No witnesses testified during the grand jury. No victims testified. A significant and compelling reason to reject the government's position in this litigation is that the government has already undertaken a comprehensive investigation into the Epstein case and, not surprisingly, has assembled a trove of Epstein documents, interviews, and exhibits. And the government committed that it would share its investigative materials with the public. There was a press release that Pam Bondi released in phase 1 of declassification of the Epstein files in February 27th, 2025. That was the day that she had all the MAGA influencers come to the White House, and she gave them all big, thick white binders full of documents that were heavily redacted and had already been released publicly. From that press release, the department remains committed to transparency and intends to release the remaining Epstein documents. The government's 100,000 pages of Epstein files and materials dwarfs the 70 pages of Epstein grand jury materials. The grand jury materials are less than 0.1% of the total number of pages in the Epstein files. The Epstein files themselves are investigatory and are not subject to Federal Rule of Criminal Procedure 6E that we're talking about here. The government is the logical party to make comprehensive disclosure to the public of the Epstein files themselves. By comparison, the instant grand jury motion appears to be a diversion from the breadth and scope of the Epstein files in the government's possession. It's a waste of time to release this document. These 70 pages is what the court's saying. The grand jury testimony is merely a hearsay snippet of Jeffrey Epstein's alleged conduct. And it's under the government's power and control to determine what they release and when. except for the grand jury documents. In February 2025, the government, as noted, was prepared to release their Epstein files to the public. But then, on July 6th, the government announced that it would not make those files available to the public. Quoting from that memo, "It is the determination of the Department of Justice and the Federal Bureau of Investigation that no further disclosure would be appropriate or warranted." There is another compelling reason not to unseal the Epstein grand jury materials at this time, namely possible threats to victims' safety and privacy. The court received a very compelling letter dated August 5th, 2025, from 3 leading victim rights attorneys who have stated, quote, "Any disclosure of grand jury material, especially material that could expose or help identify victims in any way, directly affects the Crime Victims' Rights Act sections about fairness, privacy, conferral, and protection guarantees." These attorneys represent numerous survivors of Jeffrey Epstein, including several individuals whose names and identifying information appear in the subject grand jury materials. Whether victims do or do not favor unsealing, it is imperative that victims have adequate notice of unsealing and adequate time to respond in advance of disclosure. Victims did not have sufficient notice before the government filed these motions to unseal. The government must ensure a proper review and redaction process in coordination with victims' counsel. It is critical that victims be afforded a narrow tailoring, maximal privacy protections, and meaningful victim participation in accordance with the Crime Victims' Rights Act. Let's see. And the court goes through some letters that it received, but it concludes this section by saying, Factor 1 favors continued sealing of the grand jury information. Factor 2, whether the defendant to the grand jury proceeding or the government opposes the disclosure. Jeffrey Epstein's dead. The government's making the motion. So unsealing rests on the exercise of a sound discretion under the special circumstances of each case. So Factor 2 favors continued sealing. Factor 3, why disclosure is being sought in this particular case. The government is saying that it constitutes a public interest. It is clear that grand jury materials may not be unsealed based on a blanket assertion that the public has an interest in this information. You got to have a better reason than that. The government, let's see, it says he was indicted, he was arrested, he died, the case was dropped, there's still public interest, and that came to the forefront after the government said, we're not releasing anything further. The government's assertions are legally insufficient. Factor 3 favors continued sealing. Factor 4, what specific information is being sought for disclosures? The government does not attempt to tailor discrete or specific items within the record, nor does the government seek leave to disseminate grand jury materials to a specialized audience with appropriate safeguard. Not a single victim was called to testify before the grand jury in the Epstein case. In fact, the only witness in the grand jury was a law enforcement FBI agent who had no direct knowledge of the facts of the case and whose testimony was mostly hearsay. Factor 4 favors continued sealing. Factor 5, how long ago the grand jury proceedings took place. They can last decades. But Factor 5 also favors continued sealing of the grand jury testimony. The current status of the principals of the grand jury proceedings and that of their families. Epstein is dead. Representatives of his estate take no position on the motion, so Factor 6 is neutral. Factor 7, the extent to which the desired material, either permissibly or impermissibly, has been previously been made public. Desired material refers to a relatively modest amount, 70 pages of Epstein grand jury information, which is secret. The material was sufficient to sustain an indictment, but no more. Because Epstein died at trial, the material was never presented to a trial jury, and was never subject to examination or cross-examination. It was the hearsay testimony of one FBI agent. The government has estimated that some Epstein grand jury information became public via the Ghislaine Maxwell trial. In making this assessment, the government compared the Epstein grand jury exhibits against the trial record and exhibits in Ghislaine Maxwell's trial, yada, yada, yada. Because the Epstein case never went to trial, most of the Epstein grand jury material did not become public. Very recently, the government announced that it was going to make these materials public in response to a congressional subpoena. The government's complete information trove, the files, would better inform the public about the Epstein case instead of the grand jury testimony. So factor 7 favors continued sealing. Whether witnesses who might be affected by the disclosure are still alive, they're all alive, except for Jeffrey Epstein and except for his victim who killed herself earlier this year, Virginia Jeffrey, formerly Virginia Roberts. The same agent that testified in the Epstein grand jury testified in the Ghislaine Maxwell grand jury and in the Maxwell trial. Maxwell was convicted of conspiracy to entice minors to travel to engage in illegal sex acts, conspiracy to transport minors to participate in illegal sex acts, transporting a minor to participate in illegal sex acts, sex trafficking conspiracy, and sex trafficking of a minor. Maxwell's convictions were affirmed on appeal by the Second Circuit. The Maxwell case on appeal is pending before the U.S. Supreme Court. Victims were not called to testify in the Epstein grand jury. Victims did have an opportunity to testify in public at the hearing following his death. As noted, 23 victims spoke movingly about their horrific Epstein experiences at that hearing. According to the government, there are over 1,000 victims of Jeffrey Epstein. The government, quote, confirmed that Epstein harmed over 1,000 victims. It is difficult to know exactly how many victims favor unsealing and how many favor continued sealing of this material. It is likely that victims who favor disclosure do so on the assumption that their safety, privacy, and dignity will be protected, redacted. Therefore, factor 8 favors continued sealing. Factor 9, the additional need for maintaining secrecy in the particular case in question. The Epstein grand jury materials are subject to the provisions of Criminal Rule 6E, including Rule 6 exceptions, and in the Second Circuit, unsealing applications are subjected to special circumstances jurisprudence. The information contained in the grand jury transcripts from the Epstein case pales in comparison to the actual Epstein files that the government has, the Epstein investigative information and materials in the hands of the DOJ. Factor 9 favors continued sealing as well. So in the 9 factors, 8 of them favor continuing sealing this material and 1 was neutral. Conclusion, for the reasons stated above, the government's motions to unseal the grand jury transcripts and exhibits in United States v. Epstein are respectfully denied. So that's how these orders work. That's how they're structured. That is the process that a trial judge goes through in writing an order like this. They lay out the immediate issue that they're going to deal with. They go through a factual background of the case. They lay out the law that they have to apply to those facts, and then the discussion section where they apply the law to the facts in that case. And the court here went through each one of those 9 factors from the Craig case. I don't know who appointed this judge. Let's just assume that it was Obama or Biden. Let's just assume that. You're going to see TikTok videos and commentary that an Obama judge just refused to release the Epstein files to the public. What are the Democrats hiding? So that's how you get around that kind of bullshit. You go through the actual order and you realize in painful detail that the government completely failed to carry its burden in this case, according to the law. So hope you guys found that enjoyable.